Hello. Not every divorce is hostile, though, of course, most divorces do not start out of just sheer happiness or foolhardiness or something like that, but still, many divorces are going in a non contested manner or amicably, meaning that both spouses can agree on every single point of the divorce and then present this agreement to the judge. And as long as this agreement is within the limits of the law, the judge will simply homologate, just verify, probate, whatever the word you use, the agreement, and then this agreement will become the divorce judgment, more or less. But sometimes, uh, because of some issue that cannot be agreed upon, or because of significant emotional pressure, some just bad background, the parties, the spouses, cannot agree on something or do not want to agree on something, or worse even, try to use some issue of divorce to get at each other's throat and to just get at each other, so that where like there was a simple, reasonable solution, both parties or one of them do not want to agree, and then the divorce becomes contested or hostile. So when we talk of a hostile divorce, we do not necessarily speak of a divorce that involves hostile emotions. We simply mention that in this particular divorce, there is no agreement on some issue, some matter. What could be those matters? Like where there might be no agreement. The most usual is when a minor child or minor children are involved, and like how much access each parent would have to children, with whom the children will continue to live, or maybe it will be 2 weeks here, 2 weeks there, or sometimes children live in the same place and parents come for 2 weeks or 1 week each, interchangeably, or children live with one of the grandparents and parents come, and so forth and so forth. So the arrangements around the access to the children might become a source of issues and a conflict. And connected to that, of course, the issue of child support payments, because the parent who is earning more and seeing children less usually pays more. And though legally speaking, the payment is to the children, and the other parent is only collecting this money for the sake of the children and on behalf of the children. But in the mind of the paying spouse, it's usually, why should I pay her or him, with whom now I don't have very good relationship? So this battle over children, as it seems, becomes the battle over money, and the battle over like money grabbing attitude of one, and the claims for fairness and justice on the part of another. And very often, again, the previous offenses, the previous grudges come in, while the like noble banner of child protection is used on both sides and so forth. And in such a situation, it's for a judge to verify what's the actual child's interest, and it might be that it's not what any of the parents consider it to be, or sometimes only one of the parents is selfish, and then the judge might side with the other one, or none of them are actually selfish, but they both have reasons why this or that arrangement would be better for a child. So then it will be up to the judge. Also, at least by the Civil Code of Quebec, the fact that the child spends more time with one than the other parent does not necessarily mean that that one parent has more power to make decisions about the child's well-being, including education, sport activities, and entertainment, and summer camping, and so forth and so forth. Spending on more or less expensive options, uh, schools, clothing, uh, other like after school or around school education activities and so forth. Uh, so there might be again conflicts about why did you do that without asking me, and why did you prohibit us to go there with the child, and so forth and so forth, and the question of a child's passport and agreement of both parents, and this might be another issue that might be resolved in court if it's not resolved by agreement. Of course, there is a question of spousal support, which is not always there. So most of the time it's not there because both parents are working or have their own income, and income is comparable, and the spouses are not of the age of retirement, so they have further prospects on the job market. But sometimes it's not the case. Sometimes one of the spouses depended a lot on the other, or there is some sort of health issue or an age issue or any other kind of an issue, which makes it impossible, at least immediately or maybe in a long-term perspective, for one spouse to survive independently at the more or less same level as it was during the marriage. And then the question of spousal support uh, and the amount of spousal support, the value of spousal support, might become another issue which is resolved in a hostile divorce proceedings, which, may I remind you, are much more expensive than amicable divorce proceedings. Like, might be 10 times more, it might be 20 times more than an amicable divorce proceeding. So usually it, well, in an ideal world, there should be a really big issue uh, to resolve to go for a hostile divorce. But in our world, of course, very often there is no big issue, there is no big deal, but for emotional impact on one or both sides. But that's another story. Uh, Another issue, of course, it's about property, about use of property during the divorce proceedings, which might last years and years. Uh, After divorce, like who would own the company that was established during the marriage, or at least that grew up a lot during the marriage, while the shares were only in one name or maybe both names, who would own the objects of immovable property, some other valuables, uh, pension plans, whatever is considered to be of value. Sometimes it's something that not very expensive in monetary terms, like a cat, for example. But it's dear to both hearts, and there might be a problem about that. Or some painting, which is not actually an expensive painting, but it was there for 20 years of their marriage on the wall, and there are some, again, uh, memories connected to that. And even though it was given to the family, but it was given by the parents of one of the spouses, but the other might pretend that it was given mostly to him or her because of something, and so forth and so forth. And there might be actually, not very often, but might be when there is some significant property or significant rights or precarious rights, some sort of litigation ongoing about some property in the name of one of the spouses, for example, or some investment, which, if cashed now, would result in a huge loss. But the other spouse requests that it should be cashed now, and so forth, or some shares that might be sold at a loss again if the spouses cannot continue together. So there might be additional questions depending on, again, of how much property issues are there involved. As you can see, but for the access to children, the rest of the questions mm, mostly concern with property or money. Therefore, whatever the emotional and noble and mm, moral reasons are brought up into this hostile divorce, in fact, most of the time, people are fighting over money, over property, and most of the time, that's how the judge sees it. And if there was a significant uh, opportunity, significant probability of like resolving it all peacefully, and it was not used because of specific hostility of one of the parties or both, the judge might impose some additional payments or other hardships on one of the parties or both of them because of that. But again, it depends on the judge, it depends on the court. So here it is. Back to the simplicity of it. Uncontested and amicable divorce is a divorce which is done by agreement, and contested or hostile divorce is when the parties cannot agree on at least some of it, because there is always a situation in the middle. It's not totally by agreement, but many issues are agreed upon, and only one or two are brought before the judge to decide on that. To sum up, and just finalize this question, I should remind you that most of the court decisions regarding the divorce, but for divorce itself, especially the decisions regarding the children or spousal support, they are not final. They can be reviewed later based on some significant change of circumstances. So in that case, even if something is already decided upon in the judgment of divorce, it might be later decided again, but for the fact of the divorce itself, of course. If there is some additional, new, and important change of circumstances brought up to the judge's attention. Of course, it doesn't happen like every month, but once in half a year, several years, depending on what's going on. Children grow up, their needs change, the parents' income changes, health issues might come up, some like objective situation in the jurisdiction, in the country, in the society, like COVID, for example, which prevented access to many children by their parents and so forth. So in such a situation, there might be some additional judgment after, at least in Canada, in Quebec. Thank you. And of course, if you have such a situation, you should consult your own lawyer. Whatever I'm telling you here is just general information. Do remember that when you deal with your divorce, even if you think that everything is greatly agreed upon, have at least one consultation with a lawyer. Just verify that everything is okay. Thank you, and have a nice day.